With that, I would like to now introduce our amazing facilitator for today's workshop, Ashley. Ashley is a branding lawyer and a trademark agent. She has been practicing law since 2007, and she is recognized by the Law Society of Ontario as a certified specialist in trademarks law, one of the few female lawyers to carry that designation. Ashley's scope of practice includes trademarks, copyright, contract, licensing, domain name, social media, marketing and advertising, packaging and labeling, and startup corporate laws. She's won numerous awards and accolades over the years, but most recently, she was awarded the Influential Woman in IP award by the World Intellectual Property Review, as well as the Female Trailblazer of the Year at the Canadian Law Awards. Ashley, we are extremely honored to have you here tonight. Thank you for being here. And I flip the mic over to you to begin the session.
Awesome. Well, after that, I hope I don't disappoint. That's a very, very kind and gracious introduction. Thank you. It is all true, though, I have to be honest as well. Okay, so I am going to share my screen, and I'm not the best at technology. You'd think I would be at this point. Can everyone see? Just Alina, I can see you. We're all good.
We're
Okay.
good.
So what I'm going to do, there's a lot of content to get through. And so if you have questions, that's great. What I will say is pop them in the chat group, and I will answer more general questions after I've done the presentation. It just, if I start to get barraged at side rails and people want very specific advice. So that's kind of how I'm going to flow this. So what I'm going to be doing today is giving you a primer on startup law in Canada. A little introduction to the firm. So I was a partner on Bay Street for, I was on Bay Street for the first 10 years of my career. I've been practicing for like 17 or 18 years, fast-tracked partner in 6 years. After 10 years on Bay Street, I decided to launch my own firm. So it's been about 7 years now. And you can read this. I'm not going to go through it ad nauseum, but basically we're, small but mighty. I really selected a bunch of great professionals who have, 17, 18, 19 years experience. And we provide a kind of full service approach. We're alternative to Bay Street. I work with an international network of lawyers too. So we also manage global legal issues as our clients start to evolve. We deal with startups all the way through to very established multinational companies that you probably have in your room as we speak. In terms of our ethos, we're a paperless office, women-owned business. We really try to strive for diversity in the workforce, which is something that the legal industry perhaps is not as well known for. But that's enough about us. Let's talk about what we're going to teach you. So this is really going to be a primer, and it's going to be establishing your business structure, commercial agreements, understanding intellectual property, taking your business online. And then I'm going to do a little plug for government grant funding, because we do have a government grant consultant on our team who does research and writing for companies to get government grant funding, which is a great value add. So let's first start off with establishing your business structure. You've got a concept, you've decided that this is something you want to make a go of it. It's kind of turned from a side hustle kind of hobby into something you're like, you know what? I think I might want to take a bet on myself and I might want to grow my own business. How do you do that? There's a number of different ways that, and just Alina, you're accepting all of these people in the waiting room, correct?
Yes, I am. Yeah.
Okay, perfect. So they're popping up, but I'm not doing anything with it. So there's a couple of different ways that you can form your business. The incorporation I'm going to go into first. There's incorporation, partnerships, and a sole proprietor. If you start operating your business just as yourself and you're out there and you're selling things here or there, you're operating as a sole proprietor. You are going to evolve out of that, I can guarantee you. And you might want to consider incorporating from the get-go for a number of different reasons. Let's talk about what is an incorporation and what is it. A corporation is a legal entity that is separate from you individually. It has the right to carry on business, to own property, and to maintain its own liability. The advantages of doing this, if you're operating the business as a sole proprietor, which is a fancy way of just saying you're doing it yourself without any kind of government registration, you are personally going to be liable for the risks that come with operating your business. If you run your business out of a company and you've incorporated, it means that you've created a legal entity that is separate and apart from you. Doesn't matter if you're the only person running it, but it's a legal entity that is now operating it. This means that there's a separation between you personally and the business that you are conducting. It's very attractive for that separation of liability for sure. And it means that your personal assets are not going to be subject to risk and liability. But it's also a great way for people to want to invest in you as well. So it gives you flexibility when you're raising your capital. I'm not going to go into sort of the nitty gritty. By the way, if you go to my firm's website, frozelaw.com, which I think it's frozelaw and then just .com, go to the blog section, and there's a ton of articles that I write almost every week that give you a sort of better understanding of what it is that I'm talking about. I'm trying to educate the entrepreneur community. Why am I talking about this? Why is it important? So if you're not getting all of this, don't worry. I'm giving you enough information that you can at least start to ask questions. Starting my business, what's the corporate structure? So you can do it either federal laws or you can do it under provincial laws, Ontario or federal. There's benefits to operating your company either as a federal or a provincial company. We can talk about that a little bit, but as an example, there's no Canadian presence requirements for an Ontario one, but there's additional registrations that you have to do. If you have, everyone in your company is Canadian and or a PR or a Canadian citizen, maybe you want to run it as under a federal. But there's options there. There's strategy. The incorporation process, you can operate as a numbered company or you can operate as a named company. It's up to you. I'm not going to really get into the nitty gritty. This is much more administrative in nature. So when I talk about, let me close this, sorry. I don't know why my emails pop up. So the analogy that I use when you're operating under a company is that you are creating a shelter from which you're operating. It's a separate legal entity that's sheltering you from liability and risk. So the analogy I use in this house is you have the articles of incorporation. That's your external walls and also your roof. It's just the shelter, right? That's sheltering you from the liability. In order to have a really full functioning incorporation, you also need to have a minute book. The minute book in this house analogy is the plumbing, the lighting, the floors, the separation, the HVAC, if you will, as well. It's the stuff that's inside the house that makes your company run. So sometimes I have clients that come to me in the early stages. They're like, yeah. I've incorporated through Corporations Canada. I got my number company. That's it. That's part of it. You're sort of halfway there. But how are you operating the company? How are the decisions being made? What are the registers? Who's the director? Who's the officer? And so on and so forth. So incorporating is actually incorporating your company, but then also creating this minute book, which is actually incredibly important as well. And then understand that once you've incorporated the company, you have to maintain it on an annual basis or as there are key changes that happen. So bylaws, these are sort of the governing documents that every company must have. And it's giving the directors the powers to make decisions, shareholders powers to make decisions, and so on and so forth. You have to maintain it because it's a living organism. You have to maintain. It's almost like a birthday. You celebrate it, your own birthday, but with a company, it's not as fun. You have to do regulatory registrations. But it's something that is important. Again, for those of you that are operating your business and you've already incorporated, but you haven't done the rest of the stuff, understand that if you don't maintain your company annually, within about a year or so of default, the corporation or the government is going to dissolve your company. So it is important. You also have to keep it updated for all of these changes that might occur, addresses, directors, accounting, all of that kind of stuff. So one of the cons people would say with incorporation is that there's more administrative hurdles to get through for sure, but it is beneficial for you in the longer term, especially if you have your own personal assets that you want to shelter from risk. This goes with the annual maintenance, there's annual meetings, and so on and so forth. If you are, this is another key core component of incorporating. If you are starting your business with a co-founder, with your spouse, with your sibling, with your best friend, and you guys are on some kind of equity ownership, which means both of you own shares, or however many of you are part of it are owning shares, you absolutely should get a shareholders agreement. A shareholders agreement, and it's sort of in layman's terms, it's almost like your marriage license, your marriage agreement. It is going to be easier to negotiate your shareholders agreement, which is core to how our decision is going to be made. What happens if someone has promised something but they don't deliver? What happens if somebody wants to leave? They've either been pushed out by the other shareholders, or they want to leave because they're not into it anymore, or they become incapacitated, or they die, or they move country, or life happens where they're not as invested as they were during the sort of inception, la-di-da, isn't it great, we're building a thing. And then when people start rolling up their sleeves, they realize that people are not always as aligned as they think they are. And it's critically important when you have people that have ownership over parts of your company. How do you deal with them? How do you incentivize them? How do you get rid of them in the event that it's no longer working out? And not only that, how do you start to bring in more people to bring more equity and more financing into the company? And what do you do with those original shareholders that started it off? So the shareholders agreement is something that is actually very important. You're going to be dealing with different classes, and with different classes of shares come different rights. You're going to be dealing with voting rights. You're going to be dealing with what kinds of decisions need to be made where the whole board needs, what percentage of the board needs to have decision-making authority. Do they need, a majority? Do you need unilateral consensus over everything, over some things? If you're going to do a big spend of $10,000, do you need all of the boards on board with making that kind of decision? So the shareholders agreement is something that, and the minute book is something that is going to consider all of the different variations of things that are going to happen. Think about, sometimes I find, and by sometimes I mean often, people have a concept of law that it is very intimidating, which I get. It's serious stuff and it's complicated for sure. But people also sometimes think about the law as reactionary. Judge, I object. Let's sue them. Let's get them. Let's protect our rights. I'm going to stop you now with that kind of thinking and say, think about the law as a business tool that sets out what happens in the event that things go wrong. And they will. Not everything is going to go the way that you want it, for sure. And so how do you think about these things happening whereby you're going to mitigate that and deal with it ahead of the time? I can tell you that it's a lot easier to address these issues if you have something in writing whereby you're dealing with these things or not. So incorporation, there's definite benefits. If you end up becoming successful, you are going to incorporate. I can guarantee you that. But administratively, and it can be a little bit more complex, but it's not without its advantages. So sole proprietor, we kind of talked about this before. And a sole proprietor is the most basic form of an organization. You're operating your business, you sold some widgets, it's just you, that's it. It's really hard to get investors with this. It doesn't connote a great amount of sophistication, to be honest with you. All of the income is going to be tied up with you personally, and so it gets your taxes a bit messy as well. And also, like I've talked about before, there's unlimited liability. If you're operating your business, you are operating as yourself. If you own a house, you get sued, maybe your house is up for grabs and subject to risk. Not the best way to do it. And to be honest with you, if you're really starting to get out there and getting your business going, it just connotes that you're not really at that level. Partnerships, you know, I don't deal with partnerships as much, to be honest with you. Generally, people, if they're really getting into business, they're going to be, directors, officers, shareholders. But partnerships are a way to also run a business as well. But I'll be honest with you, it doesn't come up as much in my area. Okay, so first things first, we figured out
Sorry,
that.
Ashley, there are a couple of messages in the chat. Do we want to address those before we move forward?
Nope, I want to address all of the questions. I'll go through the questions after and start to
Okay.
cherry pick. I would rather, to be honest with you, I get through the material and see if there's questions, but sometimes I can provide general answers, but sometimes I find questions get very, this is my very particular
Specific, right.
scenario, and that's not fair for everyone else.
All right,
If
sounds
you
good.
do have questions about a very specific fact scenario, you're more than welcome to email me or email Alina, and Alina will have the email forwarded on to me and I can help you that way. But general questions, sure. So let's get to commercial agreements. It takes a village to run a business, for sure. You cannot do everything. And if you are, you're selling yourself short. You can't be the marketer and the founder and the inventor and the salesperson and the web developer and so on and so forth. You are going to be bringing in third parties. It might be a web developer, it might be your SEO company, it might be a great right hand assistant, it might be someone that writes the underlying code for the software that you want to launch. It might be a sales associate. It depends. What I can tell you is that you are absolutely going to expose yourself to risk if you do not govern those relationships with a commercial agreement. And when I say a commercial agreement, I mean a written contract that is specific to the fact pattern of the business relationship. So get it in writing. Don't do the email chains. Don't sort of do the gentleman or ladies handshake. Run the business like you're going to be successful and understand that not everything's going to go the way that you want it to or assume it will. And the contract is there to protect you from that happening. So when do you need a contract? Anytime you're dealing with any third party. The type of contract and the complexity of the contract is going to evolve as the business relationship evolves. I would say that foundationally, so we talked about if you have a co-founder that's a shareholder, it's a director, an officer, the minute book, it's a series of contracts that's specific to that situation. If you have a concept and you're going to be talking about, you've got your tech pack set up and you want to talk to, I don't know, someone that's going to manufacture your beta version of it, just to see is it working. You want to at the very least have a non-disclosure agreement that is going to govern that you own the IP and they are doing this for a very small period of what they're doing. And then it's going to become more complex, the contract, as the relationship becomes a little bit more evolved. So foundationally, for sure, you're going to be using non-disclosure agreements. Every business uses non-disclosure. You're going to be using independent contractor agreements. And then depending on if you're in the service industry, if you're in the widget industry, you're going to be dealing with manufacturers, distributors, eventually agents, maybe licensee, licensor agreements as well. Why do you need a contract? It clarifies your relationship. It gives you enhanced enforcement rights. It very clearly sets out responsibilities. It sets out the rights of everyone, and it sets out the obligations and also the restrictions as well. That's another important box that I should have put in there. So there's some fundamentals of a contract. Just because you're sort of saying these are my terms, it may not be that it's an actual legit contract, because there has to be a meeting of the minds between the parties. They have to agree on it. There has to be a capacity to legally enter into a contract. There has to be some kind of consideration, I'm going to pay you this if you perform this consideration. There has to be a genuine intent between the parties to enter into a contract. And then again, the transaction has to be, the subject matter has to be lawful. We can't have a legally binding contract and I'm going to sue you for not providing me with cocaine. It's not a legally allowed product in Canada. So understanding your common contract terms, it really is important that you flesh this out. Yes, I know that you can Google and you can find contract templates, but I can tell you I have clients that bring it to me, and a lot of the terms don't make sense. To be honest with you, a lot of the terms, the contracts end up being American, which is irrelevant for Canadian-based companies where the services are being performed in Canada. So here's what you need to understand. The parties, who is entering into the contract? Can it be assigned to a third party? Are you dealing with a subsidiary? Are you dealing with the parent company? Who is performing the obligations? And is that entity in fact bound by the contract? So you really got to make sure if you're enabling yourself to enforce your rights against a third party, make sure that you have the correct third party. And it's not always as simple as it seems. Is it you personally or is it your company? And so on and so forth. The term, how long are the parties bound for? Is it renewable? Can you renew it on notice or is it evergreen? Every year it renews indefinitely. How much notice is given if you want to renew it or if you want to terminate it? What are the term obligations? It will renew if these milestones are met, for example. What is this contract about? What is the performance? Who is doing what? What are the performance milestones or deliverables? Who is performing it? Can a third party be retained to perform the obligations? What is the criteria of that performance? Who is responsible for the conduct or the work product of that extra third party? Are there quality restrictions and guidelines associated with performance? What if they are not meeting that? Consideration. What is the exchange for performance? Is it money? Is it reciprocal performance? If it is, what are the payment terms? Who is paying whom? For what? When? Is it monthly, quarterly, hourly, based on commission? What are the performance successes? Is there an approval process for additional incurred expenses? So you want to make sure that you're really honing in on, I'm hiring you and I'm expecting you to do this. And if you're using a third party, you are responsible for that person. And I'm going to pay you, but I'm only going to pay you if you have done X, Y, Z. And I'm going to pay you 30 days on delivery, and so on and so forth. What is the currency? It's really fundamental. You're dealing with someone and they think that you're getting paid in US currency, but you want to pay in Canadian. That can really impact your bottom line. Again, we talked about performance milestones, and I really try to hone in on clients to understand what exactly do you need from them. The more specific the contract, the more leverage you have to enforce your rights if it doesn't happen. And what are the deliverables? And according to whose standards are those deliverables met? You're going to eventually, it would be lovely if everyone got along all the time and relationships were indefinite, but that's not the case. There's going to be a termination at some point. How can the parties terminate? What is the difference between fault and no fault? What are the obligations upon termination? If there's a breach, what constitutes the material breach? What is a material breach? Is there a notification process with you've always got to look at not only what happens if someone does you wrong, what if you're the person? What do you do to protect yourself? So I always say that lawyers are hired guns. We are there to protect your rights, and where the leverage in an agreement in a relationship is different based on who's doing what. So how are disputes resolved? If there is it internal process, arbitration, court, where? What is the governing law? Are you going to have non-compete or non-solicit? Understand that not everything, you can't have a blanket, you can do work for me and no one else ever in the rest of your life. You have to be realistic because sometimes non-competes and non-solicits are not enforceable. Then, see, there's a lot of stuff that goes into this, and it may be a little overwhelming. I find agreements actually fun because you take this law and you apply it to the nuances of your business deal, and you try to overthink what could go wrong and what's going to happen. How could the other person do wrong by you, and how do you mitigate that? Intellectual property, who is bringing what to the table? Who owns the background IP? If it's a collaboration and there's IP that's going to be created, who owns it? Is there a license back? Are moral rights waived? Is there an assignment? Is there an obligation to not contest? That's an important one. Confidentiality. What is confidential? What's not confidential? Who can share what? Is there an obligation that extends beyond the term of the agreement? Reps and warranties, representations and warranties, we're starting to get into sort of the end part of the document, it's all legalese and it all looks kind of standard. Reps and warranties are actually pretty interesting if you're a lawyer nerd like I am, because they set out the additional outs that you might have in the agreement. Do they have the right to enter the agreement? They're not limited by a third party. They have the right to license the IP and so on and so forth. So it's additional sort of causation things that might happen that might impact the actual sanctity of the business relationship. Indemnification, legal word. I try to stay away from legalese, but sometimes I can't. Indemnification is contractually shifting the responsibility and liability. As an example, we're going to be in the widget space. I've designed something that a third party is going to manufacture, and then the manufacturing product I'm going to end up selling that to the end user. I don't have the manufacturing plant. I'm just hiring someone. Well, what if it's, I don't know, let's say it's face cream, but they ended up using really, really bad product and it burned people's face. Worst case scenario, but lawyers think about worst case scenario. That's kind of what we do. That's the whole point. What we want to do is we want to have a really strong indemnification clause that they are responsible for any legal actions that are brought against you, and the manufacturer is going to indemnify. Contractually, you've shifted the responsibility and the blame to the manufacturer who's actually responsible for it. So indemnification is going to be important for you. Force majeure, this came up a lot during COVID. The force majeure is in the event of something that's completely outside of your control and you can't perform what you're supposed to perform, can you get sued for it? So if there is a lockdown and you can't manufacture your products, you can't do it. It's a force majeure. It's an act of God. But before COVID, people put the force majeure in there. Now it's actually, we see it in real time. So does that mean that there's a union strike that's outside of your control? It's not an act of God, but things like that you can't get sued if you're not performing because you've dealt with it as something that might come up that affects your performance, but you now have an out that you're not going to get sued. Okay. I'm hoping that my explanation of this, and I go a bit detailed with contracts, but there's nuances to every contract because your business relationship between the two parties is separate and apart from any other relationship, right? So, and that's the same with different kinds of contracts and relationships. So manufacturing, you're going to be dealing with product recalls and warranty and third-party suppliers. When you're dealing with licensing of IP, you're going to be dealing with quality control provisions and royalties and sub-licensing rights. If you're, using brand ambassadors or influencers, you're going to want to look at morality clauses. If you're looking at sponsorship agreements, you're going to be looking at activations of obligations, co-branding of IP, and so on and so forth. I'm not going to get into electronic contracts too much. Generally, I prefer that you had, a contract that was DocuSigned or whatever. But if you're dealing with software, as an example, electronic contracts might be a part of your thing. So there's laws that go with electronic contracts to make sure that they're binding and proper. So contract law is provisionally governed. The web wrap and click wrap agreements are recognized as valid and binding. You have to be able to have a paper equivalent of it. It can be canceled if there's certain information is not disclosed. There's not a meaningful opportunity to accept the contract. They can't have a right to retain a copy of it as well. Okay, understanding IP, and I think it's great that you guys are gonna have the opportunity to participate in IPON. Just so you know, Froze Law is actually recognized as a preferred service provider to a lot of different entities, intellectual property granting entities throughout Canada, as a preferred service provider. So we can certainly help you with that. No matter where you're at in your business, it doesn't matter if you're service, it doesn't matter if you're, invention, it doesn't matter if you're just, not just, but just a consumer product as well. Intellectual property is going to be super important for your business. The type of IP is going to change. A couple of years ago, I'm going to take a sip of water because 40 minutes of straight talking is a lot. Hang on. Thank you. So a couple of years ago, the economic development minister of federal government, they put out, I think it was about 5 years or 40 years, something like that. If you go to my blog, there's a more in-depth article on this. And they put out this sort of proposal that Canadian businesses need to invest in their intellectual property strategy. They recognize that companies that do invest in their IP, they have increased profitability, positive impact on employment rates, and statistics have demonstrated that intellectual property intensive companies are more likely to export globally. Unfortunately, statistically, the federal government in their research noted that women-owned businesses and Indigenous-owned businesses are the least likely to invest in their IP to their detriment. So they are opting to get left behind, whereby others are carving out a monopoly in the marketplace and manipulating all of these laws to further entrench themselves, but they need the strategy in order to do that. So what is intellectual property? Kind of conceptual, but kind of not. Intellectual property is a system of laws in Canada and elsewhere, but it's jurisdictional. And it basically takes your creative ingenuity and it turns it into a right and not just a sort of abstract thing. Because of this creation of these systems of laws, Patent Act, Copyright Act, Industrial Design Act, Trademarks Act, and then trade secrets is under contract law. Remember, we talked about non-disclosure agreements as a fundamental part of your business plan. So through these systems of laws, it allows your company the right to use and have exclusivity over certain periods of time. It depends on the type of IP to use your creative ingenuity. And because you have the exclusive right, it means that you have also the right to exclude others from using it. And because of that, that's how it becomes an asset. And that's how you can get a potential revenue source. Okay, so fitting this all together, there's patents, there's trademarks, there's copyright, there's industrial design, there's trade secrets. The type of IP that you're going to be using, and it's going to be a part of your business, depends on what your business is and what the creativity is. I can guarantee you that trademarks, copyright, and trade secrets are for sure going to be a part of your business, any business, foundationally. Patents might be. Industrial design, to be honest with you, it's a bit of a sleeping giant. We can get over that kind of debate, and that's a whole other thing. But industrial design, if you're smart, use it. It's a great value add. I find that Canadian businesses don't use it as much, but it is something out there. So let's divide these out. Patents are the sexiest, they're the most expensive, but they're very attractive for investors for sure. And it really looks at the use, sale, and manufacture of inventions. I'm not a patent lawyer. I have a patent lawyer on my staff, but I'm not the one to talk about this. But if it's non-obvious, utilitarian, that is something that would be patentable. Trademarks, it's the brand. It's anything that is indicative of source. You see someone walking with sneakers and they've got 3 slashes on their side, or they have a check mark, you know if it's Adidas, or you know if it's a swoosh or Nike, as an example. You go to the cinema and you hear a lion roaring, you know that it's a movie that's been produced by MGM Grand. So you see a woman walking down the street and she's got red bottom soles, Christian Louboutin. Hey, let's get pizza 967-1111. You know we're ordering from Pizza Pizza. Copyright is it applies to any original literary, artistic, musical, and dramatic works. So tech packs, that might be something, drawings, images, website copy. I've had clients that have had FAQs on their website, and that's been integral because they can't get patent protection, but how they articulate the concept, that is something that we've copyrighted. Industrial design. If you have a utilitarian article, and it is extremely ornamental and appealing to the eye, then that is something that might be warranting of industrial design. Example would be Crocs, those ugly shoes. So utilitarian, they cover your feet, but they have a very particular kind of aesthetic that is appealing or not, depending on how you feel. That would be industrial design. Trade secrets is anything that is a market competitive advantage that you want to keep secret to yourself. That is governed by contracts. Okay, putting this into practice, we've got a pen, and it's the best pen that you've ever seen in your life. It's such a good pen that it's destroying Apple and it's destroying Microsoft, and there's not going to be computers anymore. Hypothetical, I'll just go with it. So I'm coming up with the idea of a pen, and I'm writing down sort of some formulas and sketches of it, brainstorming the pen, taking an idea, putting it in a tangible form, copyright protection. The ink is super, super special, and I don't know, it writes in space, it writes underwater, and it's connected with my brain, and it writes immediately as I think. Something like very inventive, very novel, non-obvious, patent protection. The style of the pen, it's got a huge oversized nib as an example, or a holding feature, something like that, where it's very highly aesthetic. Industrial design. I'm calling it the Who's-a-Palooza pen because I can't think of anything else. That's the branding, trademark protection. And I have been able to amass the best list of people that would like to purchase, and distributors and suppliers of this pen. It's got Tesla, and it's got Nike, and it's got NASA, and I know all of the emails and the contact information. That's a great competitive advantage. That's a trade secret. So understand that because intellectual property, we understand, is an asset, it is going to be a big part of the valuation of your business, and it's going to draw people into investing in your business. So WIPO is the World Intellectual Property Office. It's an agency at the UN. They have estimated that Fortune 500 companies have estimated that anywhere from the 45% to 75% of the wealth comes from intellectual property rights. Think about that with the slide I did a couple of slides ago about the federal government really trying to encourage small to medium-sized Canadian businesses to invest in their IP as well. This is why we want to get you guys to this part, okay? I'm going to talk about trademarks a little bit more. I'm not going to talk about patents or copyright. If you have questions about that, email me. I'm not going to get into it in a lot of detail. But trademark protection, so like I said, you have somebody that is walking and they have a swoosh on their sneaker. You already know it's from Nike, you know the where it's probably manufactured, you know the price point, you probably know where they bought it. There is an unspoken dialogue between the consumer and the company through the representation of that trademark. So trademark is something that's going to be critical to every company because you want your marketplace to know who you are and to be able to identify you immediately. Not every trademark is created equal, and I'm not going to get into this in a whole lot of detail because I think I'm running a little bit out of time. We got a lot of stuff to get through, but understand that, when you work with a trademark lawyer, there's going to be trademarks that are great. There's trademarks that aren't protectable. The Trademarks Act statutorily governs that as well. And so what you can do when you're coming up with a new brand is work with a trademark lawyer to do a trademark registrability availability search to determine, is what you're launching in the marketplace actually viable, or are you going to have challenges with it? How do you get a trademark in Canada? There's two ways. Remember how I said that you could start a business as a sole proprietor? You just put it out there and you're running your business and you're kind of out there. Same but different with common law. If you're just using your trademarks in the marketplace, it is possible that you can have common law trademark protection. It's not the most prudent way to go. Statutory protection is the way you want to be. So you want to get a trademark registration, similar to the incorporation. Same but different, similar concept. So why do you want to formalize your brand as an asset? So you're formalizing protection of your asset, you're increasing the value of your company. The registration certificate is evidence of ownership. So if there's a nefarious party that's trying to bite your style, you can go after them. You get exclusive rights Canada-wide. Trademarks is the only kind of IP that you can renew indefinitely. Springboard for international protection. No one's just operating their business in Canada. You have to go global if you want to really make something of yourself. So it can be springboard for protection in other countries as well. And it can help you with other types of brand related disputes. Someone selling some counterfeit stuff on Amazon, or someone launched a domain name that isn't actually, that's, froslaw.ca and it's a nefarious account. There's ways that you can go after people online. Understand that the trademark registration process, so if we incorporate you, you work with us to get the information we need, we can get you incorporated in about a week, 2 weeks max, with the minute books and all of that stuff. The registration process takes about 2 to 3 years in Canada. And I will tell you, it takes more on the 3 years time frame because the trademarks office is incredibly slow. They're hiring up, they're trying to amend their procedures to speed it up. But you want to file your trademark protection sooner than later for sure, before you've launched it, soon thereafter, especially for sure if you're starting to go viral in the marketplace. But understand it takes quite a while to do it. Understand also, remember how I said with the incorporation, it's kind of a living organism that you have to maintain all the time. It's the same thing with your trademarks. Trademark rights in Canada are use-based rights, so you have to be using it properly, policing it, renewing it, avoiding genericization, and so on and so forth in order to maintain your rights on that. There's a lot of different kinds of trademarks out there. So, we know these Subway, Burger King, group of numbers, slogans, designs with words and without words. What's super cool in Canada, if you're a trademark nerd like me, is that you can actually get non-traditional trademark protection. So slogans, designs, numbers, we get all of that. But you can start to get trademark protection for sounds, holograms, tastes, colors, shaping of your packaging, the shaping of your products, the positioning of a sign, the texture of something. And if you think about that in terms of strategy, and you think about the fundamental function of IP is that it gives you exclusivity and the right to exclude other people. And also you think about the function of a trademark is to manipulate consumer behavior to make sure that people are going to your company over the others. It can actually be a really interesting strategic tool to ensure that you have a strong position in the marketplace. So here's some more examples. I'm not going to get into this in a serious way, but as an example, you're getting a package delivered and it's a guy coming in a brown, or a woman coming in a brown uniform. You know that already UPS is delivering it, as an example. We talked about the sound mark. You see two motorbikes and you have one that's got that really obnoxious roaring sort of sound. You know which one is a Harley Davidson, which one's not. They have been able to get trademark protection. So they're the only ones that can use that in the marketplace, which is kind of cool. So we talk about strategy. I'm really big into strategy of using the law as a business tool to manipulate your position and enhance your position in the marketplace. So think about IP generally as a sword and a shield. So I give this example of Nesquik. Chocolate syrup. Who loves chocolate syrup? Children. They were able to get protection on the shaping of their product and the packaging of the product to look like bunnies. Who loves, these kind of cartoonish characters? Children. So already they've sort of manipulated that how their product looks and is marketed on the shelf is going to manipulate their target audience and draw them in, and they got exclusivity over that, which I think is kind of cool. Patent law, again, I got to be honest with you, I'm not a patent lawyer. We've got someone around that can help with that. They don't need to be large monumental inventions, but they do have to be new and non-obvious and a practical improvement of an invention. What is a patent? Again, we've talked about this, the right to exclude, it's a monopoly, and so on and so forth. I'm not going to talk about this so much, I'll be honest with you. Patent applications, they are more in depth. They are more expensive, but they are certainly more attractive. And it's something that you should look into and consider for sure. And similar to the trademark registration process, it is quite an ordeal to get a patent for sure. It's a lot more complex than a trademark. But you want to work with patent agents, with the patent office, and so on and so forth. Understand that patents are territorial, as is every type of IP. So it's a country by country basis. So you're going to have to deal with that as well. Okay, I'm not going to get into this so much. If you do have questions, email me afterwards. Industrial design protection, we talked about this. It kind of falls between copyrights and trademarks and patents. It's protecting visual features of products that are ornamentational on utilitarian features. So, beverage containers, shoes, jewelry, electronic consumer products, and so on and so forth. These can be helpful for you. And, it's interesting. And then there's this interplay between the trademark, non-traditional trademark protection and industrial designs. I'm not going to get into the weeds in this so much, but you know how we talked about the trademark protection for the shaping of that chocolate syrup bunny bottle, correct? In order to do that, there's certain thresholds under Trademarks Act that may not be as present under Industrial Design Act, and there's a strategic interplay between them. Not going to get into it too much, but like I said, and what I'm trying to drill down is that there's strategy. One thing that you have to be cognizant of if you're interested in industrial design and also with patent protection is that there is a finite period of time for which you have to file for application to get protection. Trademark protection, copyright protection, you don't necessarily have to get a registration, but it's prudent to do that. Industrial design protection and patent protection, you have to get a registration in order to be protected, and you have to start the process within the first year of public disclosure. Okay, taking your business online. Okay, taking your business online. You can't operate your business without taking it online. Fundamentally, you're going to have a website. If you're more sophisticated, you're going to have e-commerce. If you're more sophisticated, you're going to have an app. You're going to have social media. If you're in the consumer goods, you're probably going to start to get into influencer marketing and all of this stuff. Understand that people have this misconception that because you're online, it's the Wild West and no one can enforce anything. That is not the case at all. In order for all of these platforms to be created, Twitter or X, Facebook, Amazon, Alibaba, all of this stuff, all of these platforms, foundationally, in order for them to be successful, they have to get buy-in from the big brands, right? If no one's going to sell on them, then they can't exist. In order for them to get the buy-in from the brands in order to use their marketplace, they have to have the systems and the policies in place that enforces their intellectual property rights. So within each of these different platforms, they're going to have their own governing policies and also enforcement mechanisms by which you can enforce your rights against nefarious third parties, or you have to comply with if you want to use their ad spend or whatever. So understand that it's not the Wild West. You do have to comply with each platform's policies as well, and also governing legislation. So Canada's Competition Act deals with contests and market and rules. The Competition Act also deals with deceptive marketing practices. The Copyright Act deals with third-party generated content. Trademarks Act deals with third-party trademark rights. I don't know if you're getting into the cannabis world, but there's strict brand promotion restrictions through the Cannabis Act. There's privacy laws, the Canada's anti-spam legislation, which deals with e-marketing campaigns. So I hope that you guys understand that managing your third-party relationships is going to be very important. How do you do that? You do that through a series of agreements, written agreements that are specific to you. So we're looking at independent contractor agreements, sponsorship agreements, brand ambassador agreements, influencer marketing agreements, web and app developer agreements, user agreements, and so on and so forth. If you are going to have a social media platform and you're going to have your third parties, eventually you're going to end up hiring, someone that's in their 20s to handle your social media platform. You can't do everything. You're going to evolve out of it. Who's going to own your social media, handle the contents, the social media contact lists? How is your brand portrayed? What are the guidelines? What are the restrictions? Are you going to have a free-for-all, or is there going to be one point person that's a communicator? If you have a platform where you're allowing third parties to post, how are you going to make sure that they have guidelines? What kind of content? You can't post personal information. What if they do? What if it goes viral and it's really negative content? How are you going to handle that? And so on and so forth. Same with moderation policies. Influencer marketing. Do not think that influencer marketing is just a vacuous sort of fluffy, silly industry. It is taking over and it is highly, highly lucrative for sure. So much so that the federal government is actually starting to place more and more policies out there on managing influencer marketing. So understand that there's a whole slew of government restrictions on how you use influencer marketings, or on how influencer marketing is governed as well. You've got to have best practices and know that you will be followed up with as well. Understand that if you're going into the States is very, very on point with enforcing as well. So you need to be on point with that. I'm wrapping up soon. And I want to give a shout out for government grant financing. You have a session coming up, that's great, go to it. We also have a government grant consultant on our team who helps our clients with researching and writing for government grant funding. There is money available for you, for sure. Well, actually, I'm not going to say for sure. No lawyer should ever say that. What I'm going to say is there is government grant financing available on the federal, provincial, and municipal level. Each of those different layers of government have different agencies. Each of those agencies have different things that come up that they want to finance. It is not static, it changes all the time. It changes with political will, it changes depending on what is happening. All of a sudden, the government has put out a bunch of money that's available to help with the hospitality industry to come back in Jasper. It's very reactionary in that way. If you go to our firm's website, froselaw.com, go to the blog section, we have tons of articles on how do you get your financing available. Understand that grant financing is non-dilutive, non-repayable funding that is available to you that supports specific business initiatives and projects. There's different levels of government, which means that it changes a lot. And the grant programs are designed to support specific policy initiatives and social and economic goals. So that's something which is why it's changing as well. Here's an example of the types of grant funding that might be available: hiring students, upskilling existing staff, talent, supporting DEI, research development, expanding your market, going into trade shows, investing in your IP. That's a big one as well. Capital spend, if you're starting to export as well, that is something. As with everything else, you want to make sure that you have strategy in play and that you're trying to get ahead of, okay, what do you have coming up for 2025, and what kind of funding would be available for you. It is free money in that you don't have to pay it back. It's not a loan. It's not free in that you do have to do some legwork in order to get it. Just because you want it doesn't mean that you are going to get it. but it is something that I find that entrepreneurs take a sort of sit back on, and there's money available for you. Now, I've said a number of times, you're welcome to reach out to us. We issue out newsletters every 2 weeks. It's got updates on the law, it's got updates on grant financing as well. Go to our firm's website. So if you go to our firm's website, you can subscribe to our newsletters. It goes out to like, I don't know, 5,000 or so. Follow us on these different channels as well. And also go to our firm's website, go to the blog section. I write this stuff to try and help educate and level the playing field so that you understand what it is that we are talking about. So that is it in a nutshell. And I'm going to stop sharing. Like, you guys are all still there. 72 people still there. That's pretty good.
Yeah, thank you so much.
Honestly, this was great, Ashley. Sorry, go ahead, over to you.
Yeah, I was just reiterating what Alina was saying as well. This was so great. I have a few questions of my own that I will also get to at the end, but there is a very long list of questions, so I'm going to start from the very first one.
To be honest with you, let me go through them.
Okay.
What
Yeah,
I'm going to start to go through, and I'm going to sort of triage, if that's okay.
of
Sometimes
course.
they're
Sounds
very, very specific.
Mm-hmm.
I'm not going to get into that, but I'm going to do my best to try and do this. Would a minute book include meeting minutes as well? Yes. What does incorporation look like when you're the only one starting your company? So you could be an owner, operator, that you would be the sole director, officer, shareholder. That is entirely fine. You can keep it that way. You can grow it to be bigger. But the whole point is that you are separating yourself from personal liability and risk. So a lot of my clients, when they start off, they are going to be owner operators, sole owner operators, sole director, officer, shareholder. But oftentimes we'll structure it so that there's another class of goods to, or sorry, class of shares, that if they start to bring in people that want a bit of equity, we've structured it in that way. It's all dependent on the individual fact pattern. What if you're pre-revenue and currently a registered business, like a sole proprietor, should you incorporate? So, and then you've heard that you should wait for the revenue and all of this stuff. If you have the chutzpah that you think you're going to make a go of it, and also if you're in a situation where you have a car and you have a house and you're dealing with something where there is a liability kind of risk and you want to protect your own personal assets, absolutely incorporate. I can tell you, when I launched my firm at the same time as another lawyer that left the same firm I was at. Fred is out. Bye, Fred. So I called you out, Fred. So we launched it at the same time. He did not incorporate. We had to go through professional corporation, is a little bit different. He didn't incorporate, and he ran as a sole proprietor. I decided to incorporate from the beginning because, frankly, I believed in myself. I knew I was going to be successful. When he got to the point where he needed to incorporate for tax benefit purposes, et cetera, he was so busy that now he had to sort of redo his company, new banking. He had to assign over all of his contracts to this new company. He had to update everyone, all of his retainer agreements with his clients, and so on and so on and so on. Pain in the ass. I'm of the mindset that if you know you're going to do this and you know you're going to be successful, just set it up, do it properly so that you don't have to deal with administrative hiccups when you're on a trajectory. That's my personal thing. Accountants might have a different perspective. Does any of this relate to a real estate business? Yes, this is basic information that's relatable to everyone. How easy is it to switch from a sole proprietor to being incorporated? It's the same process. The only big difference is that we would then assign over all of the contracts that you've already entered into, and there might be like, if you have a registered sole proprietor business registration, we have to close that down. Happens all the time. It's not insignificant. Is it legal to use our client's logo on our website? Yeah, absolutely. But you want to make sure that it's a viable trademark or a viable logo. So you might want to do your due diligence ahead of time. Oh, I'm a great speaker and I'm very informative. Love that. Thank you, Andrea, with a couple of hearts. That's great. I think I'm seeing these are all of the questions.
Yep, you've caught up. I do have a question as well, though.
Right.
When you were talking about trade secrets earlier as like protecting suppliers, my question with that was what exactly do trade secrets protect? Is it confidentiality or is it who the suppliers actually are?
It depends. Totally depends on what what are you protecting? Who are you protecting it from? It, it's so, a lot of these things are so specific to what is your market position, what's good for you. Do you know what I mean?
Yeah. Yeah, that makes sense.
So these are all general principles, but unless you actually get into, it's sort of like, you want to get married. Marriage is a thing, but how are you going to do your finances and who's going to be responsible for the chores and who, it's the nitty gritty of the actual relationship. Every marriage is different. It's the same with your business and the strategies behind it.
Sounds good. Okay, that makes sense. Perfect. Thank you
Okay,
so
what are my thoughts on operating under a named company or a numbered company? I don't love numbered companies. I can tell you this is that if I need to ask a client, okay, so what's your legal entity name? Oh, it's like 13702. I don't know what it is. If you want to incorporate a company quick, you're not sure what the name is, you just want to get it out there, sure, let's just deal with that. And then we can figure out what the company name is, amend it, all of this. Generally, though, I just don't think it's bear in mind, I'm a branding lawyer, right? So I just don't think that, hi, I represent 1732002 Canada Inc. is really as impactful as I'm the founder of Froze Law. Do you know what I mean? Like it's different. Personal preference, not a legal thing.
Perfect. Sorry, were we able to take Maydie's question as well? Just want to make sure.
So for consumer goods products, how do we indemnify ourselves from a manufacturer's agreement? You include that in your manufacturing agreement. Go to the firm's website, frozelaw.com, go to the blog section. I have an article that is very specific to type in the search thing, manufacturing. And I have a whole thing of what are the terms that are very specific to manufacturing agreement and relationships. So that's a big part of what you want to think about as well. And that's the example I gave. Remember that terrible example of someone using face cream and burning their face off? Remember we talked about indemnification? That was that example.
Awesome, Ashley. And I was wondering because we sometimes get like non-for-profits or social enterprises connect with us as well. So in terms of like incorporating and stuff, for non-for-profits and social enterprises, is it the same process or
It
business
depends.
structure? Yeah.
Non-for-profit, so you're running your organization either as a sole proprietorship or it depends. If it's a non-for-profit, same but different than an incorporation. It's a little bit different. The articles of incorporation are a little bit different. The governing legislation is a little bit different. If you are going to be operating as a charity, it's that much more of regulatory because you're getting the tax benefits and that kind of stuff. So it's same but different, a little bit more complex, not insurmountable, but something.
Got it. And another question, Ashley, we work with a lot of early stage founders who are at that ideation phase where they're still validating, they're building out their solution and their MVPs. At what point would you recommend them to start looking into IP?
Immediately, as soon as you have an idea, especially because depending on the IP, you're going to be, the clock is going to start ticking. But as an example, especially in the consumer goods industry, if you're starting to look at a manufacturers, for example, I would tend to ensure that you invest in your IP or at least the tech pack, get a non-disclosure agreement, and then start to send it out. Because what assurances do you have? Give yourself some kind of leverage to enforce your rights.
Got it, got it. And then I see there are two more questions in the chat.
And then after this, can we wrap it up?
Yes, absolutely.
Awesome. Okay, what advice can you give companies entering a relationship with an entity who wishes to test or pilot our product solution? Oh, so that's kind of what we talked about, confidentiality, restrictions. it's all of that same stuff. It depends what obligations or considerations should be made. Well, what are they doing? It's what is actually happening in this relationship? What do you want to happen? And then from that, we then architect the contract to deal with that. Would an incorporated social enterprise be the same as a for-profit corporation, not a charity? It depends on what it is we're dealing with. Is a non-for-profit? Is it? I'm not really sure. What are some pro bono legal services? If we don't have the funds to start, go to the Law Society. You can get pro bono stuff that way.